Lord, here I am being asked by the person who did not choose to face the vote of no confidence, that why did you call for the vote of confidence? Why did you call for the floor test? The converse situation and more drastic, my lord, in terms of the facts. Wherever a doubt arises, whether the Council of Ministers has lost the confidence of the House, the only way of testing it is on the floor of the House, except in an extraordinary situation where, because of all pervasive violence, the governor comes to the conclusion and records the same in his report that for the reasons mentioned by him, a free vote is not possible in the House. So, my lord, it's not his right, it's his obligation. And, my lord, the threshold in my respectful submission is that some material which creates a doubt in his mind. And, my lord, I would, my lord, at the cost of repetition and with profound respect, my lord, please, this is a constitutional submission, don't my lord, misunderstand the submission. My lord, the threshold of your lordship's judicial review, which I am not disputing, would be whether there was any material, whether based upon that material, your lordships may perhaps would have taken a different view, may not be a test. Now, your lordships, my lord, kindly come to Shivraj Singh Chauhan, my lord. The precedent of this court in regard to convening of the trust vote have arisen in the context of fresh elections held to the legislature and not in the context of a running assembly. My lord, Shivraj Singh Chauhan was a case of a running assembly, and in the midst of the, my lord, the government functioning, the then chief minister lost the confidence. This is what your lordships were dealing with, my lord. Mr. Sibal contends that the observations of the Constitution bench in Nabam Rebia on the authority of governor to order a trust vote to be conducted on the floor of an ongoing legislative assembly are purely arbitrary. But Nabam Rebia was also an ongoing assembly, not first time government formation. The case before the Constitution bench in Nabam Rebia dealt with a situation where the governor had preponed the date for meeting of the legislature assembly to decide the question of speaker's removal. It was submitted that Nabam Rebia is not a precedent for the proposition that the governor is entitled to require a trust vote to be conducted on the floor of a legislative assembly, which has been duly constituted and is in session. Mr. Sibal submitted that the consequences of upholding the power of governor would be to encourage both the demolition of an elected government and the democratic structures of the governance. Mr. Sibal's submission, governor would have the power to summon the House where it is not in session. Since under Article 168, the governor is a part of the legislature, if the House is not in session, it is open to a governor to seek a special session where facts indicate that the existing government has lost its majority. But this is in support of what I did as a governor. That if it's not in session and my lord, something would turn, my lord, on his written another argument that no confidence motion was the only way and not the confidence vote by floor test. However, in a similar vein, Dr. Singhvi's submission, Mr. Sibal urged that this course of action is not open to the governor when the House is in session, and in such an eventuality, the only remedy is to seek a motion of no confidence to test whether the incumbent government is possessed of the confidence of the House. With respect to exercise of the power of the governor by calling for a trust vote, it has been submitted by Mr. Sibal that there must exist an objective satisfaction of the governor based on material in his possession. Absent a physical verification, it cannot be said that mere tendering of resignation by members led to valid exercise of power by the governor to call for a trust vote. Here, my lord, withdrawing support from the government. In the present case, the governor had no material to conclude that 16 members had submitted their resignations voluntarily. Legislative history in the country indicates that minority governments have survived, and unless it is shown that mere tendering of resignations actually caused the loss of confidence in the incumbent government, it is not open to the governor to conclude that actions of the 16 members would result in a loss of confidence. Here, they specifically say in writing that we want to withdraw support from the government. Now, my lord, questions before the court, my lord, kindly come to PDF 1371, para 46. The present controversy raises two separate but intertwined constitutional questions. First, whether the governor is entrusted with the authority to call for a trust vote in the course of a running assembly. And second, whether the governor exercised this authority correctly. If the governor does not possess the authority, the action of calling for an immediate floor test is ultra-vires and unconstitutional. Alternatively, if the governor does possess the authority to call for a floor test, this court must determine the contours of such power and answer the question of whether the governor acted within these contours. Para 50. Constitutional role of the governor. But I don't think, my lord, anything more is required to be said by me, except, my lord, very respectfully adopting my lord's judicial determination. We must consider the constitutional scheme in operation between the state legislature and the office of the governor. As a matter of constitutional principle, the state legislature comprises of the governor and the legislative assembly. The governor is not an elected member of the state legislature. The governor is appointed by the president and is the head of the executive branch in whom, under Article 154, the executive power of the state is vested. While holding office at the pleasure of the president, the governor as a constitutional authority, is not a member of either House of Parliament or the legislature of the state. The Constituent Assembly thus decided to vest the office of the governor with certain discretionary powers under the Constitution. In taking this decision, the Constituent Assembly was aware that there were certain associated risks in granting the governor discretionary powers, including in question of formation, disruption, and dissolution of democratically elected governments. However, the framers felt that this discretion was necessitated by unique historical factors that existed at the time of adopting the Constitution, and it was hoped that with the maturing of our polity, a level of constitutional statesmanship and trust would paper over the cracks of constitutional choices necessitated by more violent times. My Lord, kindly come to, my Lord, para 61 at PDF page 1377. Lord, all arguments which are made here were advanced, were present before your lordships, and my lords were thereafter, my lord, pleased to lay down the law. Para 61. The issue of whether a governor can call for a trust vote in an already constituted legislative assembly is not entirely res integra. Before a 9-judge bench of this court in S.R. Bomai, the individual cases which came up for consideration included the dispute emanating from the state of Karnataka. In the state of Karnataka, following elections to the assembly in March 85, the Janata Legislature Party emerged with the majority. Shri Hegde was elected as the leader of the house. Lord, kindly allow me to read these facts. Lord, there is something, Lord, which may assist your lordships. Shri Hegde was elected as the leader of the party and was sworn in as chief minister. Following his resignation, Shri Bomai was elected as the leader of the party and was sworn in as chief minister on so-and-so. In September, there was a merger of Janata Party with Lok Dal B, resulting in formation of Janata Dal. On so-and-so, a legislator defected from the party and presented a letter to the governor of Karnataka withdrawing his support from the Janata Dal government. The legislator met the governor on the next day and presented 19 letters purportedly of 17 Janata Dal legislators, an independent and a BJP legislator withdrawing support from the Janata Dal government. On so-and-so, the governor sent a report to the president opining that as a result of withdrawal of support, the ruling party had been reduced to the minority in Karnataka Legislative Assembly and recommended that action be initiated under Article 356 of the Constitution. Because if this is the correct assessment of the governor, there are two options, either go for a floor test or 356, which your lordships have frowned upon. Subsequently, on so-and-so, 7 legislators submitted letters to the governor complaining that their signature had been obtained by misrepresentation and reaffirmed their support to Shri Bomai's government. The state cabinet decided to convene an assembly on so-and-so, and the chief minister met the governor, offering to prove his majority on the floor of the house, if necessary, by preponing the assembly session. In spite of this, the governor submitted another report to the president on so-and-so, and a proclamation was issued under Article 356. Then 66. As a matter of constitutional law, it would not be correct to proceed on the basis that constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised at the very inception after general elections are held and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. Therefore, I said he should not only command the confidence, but continue to command the confidence. That's, my lord, the requirement of democratic functioning. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands the confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called in question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. It must be noted that governor does not decide whether incumbent government commands the confidence of the House. The purpose of holding a floor test in the Legislative Assembly is precisely to enable the elected representatives to determine whether the Council of Ministers commands the confidence of the House. That verification is not conducted by the governor. The decision in SR Bomai, in fact, held that recourse to the power under 356 was not warranted in a situation. Your lordships can, my lord, skip the rest, my lord. Now, para 68, your lordships were pleased to reject the argument. The argument was that the exercise of power by the governor under Article 174 and 175 should also be based on aid and advice. Your lordships were pleased to, my lord, reject that submission. My lord, I am not, my lord, troubling your lordship with that, my lord. Now, my lord, 69 at page 1383. My lord, judgment after judgment, it is settled, my lord. Please allow me to place Nabam Rebia, my lord, only.
Just the para 71 and 72 also.
Yes, I'm coming to that. 70 also. 70, according to I'll read 70. We are unable to accept the submission of that the observations of the Constitution Bench in Nabam Rebia are obiter. The observation in Nabam Rebia are consistent with the formulation of principle in the 9-judge bench decision in SR Bomai, as we have discussed earlier. Please note, my lord, the power under Article 174 of the Constitution to summon the House and to prorogue it is one which is exercised by the governor on the aid and advice of the Council of Ministers. But in a situation where the governor has reasons to believe that the Council of Ministers headed by the Chief Minister has lost the confidence of the House, constitutional propriety requires that the issue be resolved by calling for floor test. The governor, in calling for a floor test, cannot be construed to have acted beyond the bounds of constitutional authority. And, my lord, loss of confidence mean in a running assembly. Now, my lord, your lordship may, my lord, kindly 71. The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of discretion by the governor to call for a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane. These are the potent words used by our lordships. It should not be irrelevant material or something completely not germane to the issue. The exercise of such power is not intended to destabilize or displace a democratically elected government accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of satisfaction by the governor is not based on extraneous considerations. So, my lord, when there are extraneous considerations, your lordships would step in and exercise the power of judicial review, and extraneous would mean completely irrelevant and not germane to the issue. Issue namely whether the governor would be justified in forming an opinion or entertaining a doubt about the government having lost the majority support. If the documents are not irrelevant or not germane, then, my lord, perhaps your lordships may not take a second guess on the basis as to what your lordships would have perhaps perceived the situation to be capable of.